We hope you enjoy this video from Level 5. Don't forget to subscribe and turn on notifications for all the updates.
Hi everybody, it's Alex from Level 5. I'm here with Chris Jackson from Burges Salmon, which is a legal firm. Why are you here?
Because law needs to be an enabler, not a blocker for where we want to be in a different future. We need to set it up in a way that works. We start with a number of areas of law that are critical to autonomous vehicles, three in particular. One, the liability model. Secondly, cybersecurity. Third, data. We're going to be in a different world in each of those three areas, so we need to work through each of them and say we have different requirements, so what does that need to look like? What is the new legal part of the system?
Starting with the last one there, you talked about data, presumably with relationship to the data that's gathered by the vehicle and processed by the manufacturers and the companies in the supply chain of the vehicles.
Yes, clearly data law is a huge issue for a lot of people at the moment, but what data law always does is catch up with the last problem. So the thing that's just come in, the General Data Protection Regulation that's bombarded us all with less than fascinating emails about consents and so on, that is a very vital piece of legislation, but it's really directed about social media and the intrusion into people's personal data. Very important, but it's now got to be applied to a different application, which is vehicle technology and systems and transport technologies, and it does have the flexibility to do that, but what it does mean, we've got to start talking about data in segments, not just data as a mass, the stuff that isn't sensitive, that nobody's particularly bothered about, the personal data that people are, the very sensitive stuff, personal medical data or behavioural issues, and then there's the proprietary data that the manufacturers and the people in the supply chain genuinely have an interest in keeping secret, and somehow we've got to make all that work together and use the law that we've got to make that work.
If you look back at the Data Protection Act and earlier acts, the spirit is there, but they just didn't have the teeth to go after people who did bad things with data.
Yes, it is about teeth and misuse, but it's also about looking at what you want to use data for and what is legitimate use and what is the balance between those two things, and not having all those categories looked at in the same way. So to take an example, if biomedical data is gathered as part of autonomous vehicles, and that may well be because it might monitor driver state or driver health, if we're opening up technology to people within society that don't currently have access because, for example, they're epileptic or they're a disabled person, then that data may need to be gathered. That has to have a very high level of protection, and the law needs to protect that. If we're talking about something quite bland, then we don't want to apply the same rigour, because I think society will expect there to be a trade-off. Let's take location data, for example. There is a right within the GDPR to turn off location data. That's not a terribly good idea if your autonomous vehicle relies on that location data to know where you are on the system. So we've just got to be flexible and adapt what we need to the particular system.
It's a civil rights question. Do people want to have greater authorities, whether that's technology manufacturers or governments, what have you, always knowing where they are? If, for example, they're on the run or they haven't paid a particular bill, is it fair to impinge on people's freedom of movement?
I mean, the reality is at the moment is that there is a huge amount of data that we all consent to, and it is about consent, but the apps that we sign up to will have those consents built into their terms and conditions. There is a much bigger piece that goes way beyond technology. The underlying point is there is a balance to be reached, and that is the debate that is going on in transport and everywhere else. Certain bits we have to share. So if you take location data within a system, the system has to know where you are in order to safely navigate around other things. Some people will have a legitimate need to know what the medical data is, but only a very small number of people for a very specific purpose. What we've got to do is map consent against purpose, against need, against societal consent.
Let's say I've got a heart defect and my steering wheel is measuring my heart rate through my conductive pads on the steering wheel. Some company buys that data and wants to target adverts to me for some heart medication. In broader terms, I mean, what was the moral balance on that?
There's the moral balance and then there's the legal balance around it. They've got to align with each other ultimately. The moral basis of any legal structure needs to have moral buy-in, you're right. You can have constraints which go beyond the legal. Underlying point is you need to separate out mass data and agglomerated data, so movements of flows between people as to where they go, and you can see what the trends are across cities in order to manage the system. And agglomerated data, people will accept a far greater use than individual level data, where there needs to be a trust and a consensus ultimately on what the need is and what it is being used for and who it is accessed by. If medical data is going to be used and some organisation wishes to use it to target specific services, whether they're health services or adverts or whatever, the consents and the trust around that need to be built into the system by design from the start. At the moment, arguably, they're not on the wider use of data around the internet. But if they're not ultimately, that will affect the underlying trust in any system, whether it's a transport system, an internet, a medical system or whatever. So that does need to go into the design.
So you mentioned liability and also cybersecurity, which I think, broadly speaking, are subjects which are fairly well understood, because you've got obviously the insurance sector, you've got manufacturers talking about those topics as well. If I can ask for some comment on those 2 points, cybersecurity and liability, in the projects that you've been involved with most recently through Innovate UK, because you're working on some of the autonomous vehicle trials in the UK, aren't you?
That's right. The ones that are at the most advanced stage of the 4 or 5 we're involved in are Ventura and Flourish. Ventura has really been looking at the liability model, and we've been working very closely with AXA, who in turn are plugging into the insurance industry, and we've been co-authoring the reports, basically to look at the future of the liability model so that it works. Both civil liability, which is about money flows and who gets compensated for what and what triggers those liabilities, so there isn't a hold up in the system, but also different levels of vehicle autonomy and so on, to a certain extent to the criminal liability, because you cannot base the whole system on just moving forward from where we start, which is individual driver-based fault. At the moment, broadly, driver liability is around paying attention. I'm simplifying because you need vehicle standards and things like that. But if the whole point about CAVs is that the driver need not be paying attention when you get to level 3, 4 and 5. You can't build a liability model around that lack of attention, and our latest report in particular has been looking about the transition from when the vehicle is running the driving task to hand back to individuals, and that all needs to be quite carefully modelled. Standards are being developed and they're being done at a European level and also at a global level. There is a general consensus that when you're at level 1 and 2, the position is relatively clear. The driver still has to take responsibility and control and monitor. When you're up at 4 and 5, that is really a product liability situation. The vehicle and the wider transport system is in charge and taking the system. The really knotty issue around handback in particular is around level 3. Because if as humans we are disengaged from a task because we are legitimately doing something else, we all know that you can't get straight back into it within a microsecond. And that is what Venture in particular, the technical trials we're looking at. We're mapping both in simulation and in real vehicles how long it takes people to switch back on.
So not just the disengagement for whatever reason, but also being able to take back cognitive control of a vehicle in a complicated situation.
Correct, it's not instant.
I think I saw a study at possibly Portsmouth University were finding that in some very complicated circumstances it was taking anything up to sort of 10 seconds to re-engage.
Or sometimes even longer. The simulation trials in Ventura and also the real vehicle trials similarly made similar findings, which clearly in an active situation is too long. And that is leading into an interesting discussion as to how level 3 is regulated. The government should take great credit from having been proactive in the insurance provisions of the new legislation, the Autonomous and Electric Vehicles Act as it will be. But what is not clear is whether the level 3 will be classed as an automated vehicle. And that's important because if it's classed as an automated vehicle, regardless of what was happening and who was in charge at the time, the insurers will pay out. That will not be the case if it's not classified as an automated vehicle.
So there's a bit of gap in legislation and understanding in the liability, the legislation and everything.
Well, it's not a gap as such, it's just during this phase of the development of legislation, there will need to be clarity on whether level 3 is caught or not. That is a policy choice. It either is or it isn't, and that will be a policy choice to be made by government.
How did you end up working with autonomous vehicles?
My first degree was law, qualified in 1990. I started doing insurance, and I decided to do that in the newly privatised rail industry in 1995. Went round all the new rail insurance companies, because British Rail didn't have insurers, and looked at system liability and this new industry that was there. That led me to be closely involved in all of the major rail accidents which occurred from 1997 to 2002. I was acting for all the UK train operators, and the legislation and the policy formulation that followed from that to improve system safety, which did make a step change, that legislation that came out of the inquiries and out of the government review. Then become head of our transport sector, so I look at other modes now, a lot on highways, a lot on roads. We do some on aviation and marine and ports as well, but it's really been that journey through looking at regulation, but also how all these bits bits and things fit together, which is what I find interesting. I'm very lucky. I'm not a technology lawyer, but I'm fortunate enough to work with a lot of very talented lawyers within my team that are, so keep me on the straight and narrow in relation to the technology aspects.
Chris, that's really great to hear. Thank you so much for your time. And, well, I guess in summary, if you want to work with autonomous vehicles, get a law degree. So there you go. That's the takeaway. Don't forget to like and subscribe to the video. Just click wildly below a thumb, a little bell or anything, or leave a comment. And we'll see you soon. Thanks a lot. Bye-bye.
Thanks for watching this video by Level 5. Don't forget to follow us on Twitter @Level5Jobs and check out our website level5jobs.com.